This informational video does not create an attorney-client relationship and is not to be considered as specific legal advice. It is very important to be able to classify property in Louisiana as either community property or separate property in dealing with a divorce matter or an estate planning matter. Basically, property is going to be considered community when it's acquired by parties who are married who do not have a prenuptial agreement during the time of the marriage. So the time period that we're looking at to determine if it's community is going to be from the date of the marriage through the date a divorce petition is filed. All assets acquired during that time are generally going to be community property, and all debt incurred during that time is going to be considered community debt. Separate property is going to be considered property that is acquired by the parties prior to marriage. Also, any property that's donated to one of the spouses or any property that is inherited by one of the spouses would also be considered their separate property, even if it happens during the time of the marriage. Further, any property that is acquired after the divorce petition is filed is going to be considered separate property, and any debt incurred after the divorce petition is filed will be considered separate debt. So those are the basic differences between the two. There's tons of nuanced rules pertaining to separate property and community property in Louisiana, so it's always good to speak to a lawyer first to determine how to classify the property.